Good afternoon.
Good afternoon, Assemblymember.
So I just wanted to start out by asking you a simple question, which is the governor's recommendation for $200 million to support the Raise the Age program. I guess that's for the 16-year-olds and not the 17-year-olds that we expect to come online next October.
My recollection is that there was $100 million in last year's budget, and that was for the 16-year-olds that came on starting October 1st. And it's my understanding that the $200 million would reflect the fact that 17-year-olds will come under the coverage of the new statute October 1st of this year, and that $200 million would resource the system for both 16 and 17-year-olds.
So I want to talk a little bit about something that's not in your testimony, but concerns me a little bit regarding an article that appeared in the New York Times referring to DNA as a new so-called magic box that you may have seen. It's a new way of processing DNA.
I did see the article, yes.
And it's not the first article that's talked about the issue of DNA and how it's used or misused. And so in 2017, the federal government enacted the Rapid DNA Act, which would allow rapid DNA machines to upload DNA information to CODIS. And obviously there have been a lot of developments in science that are above me and above my scientific knowledge that I'd like to know a lot more about so that I can understand them. But I'm wondering first, how many DNA samples are now contained in our database, in the state's database?
I don't have an exact number, but I believe it's in the neighborhood of 500,000.
And how many of those are volunteer samples or non-offender samples?
I believe it's a very small percentage.
And are those, I always wondered whether those are returned after the investigation concludes, or are they maintained for a longer period of time?
In the state database, I don't believe there are samples that fall into the category you're referring to. I've read articles about local databases where police, in the course of an investigation, take a sample and then keep that in the local database. The ones I was referring to in the state database are ones where, as a condition of a plea, for example, or of a condition of a sentence, a defendant agreed to give a DNA sample to be put in the state database prior to the time where all crimes DNA, which this legislature passed, took effect. That was a practice, I know, and there are samples in the database that fall into that. But in terms of the investigative ones that you refer to, there are, to the best of my knowledge, no samples of that type in the state CODIS data bank.
So I think you might remember back when the New York State Assembly Codes Committee held hearings on the Forensic Science Commission. And I was kind of puzzled back in those days to figure out a lot of different things about familial DNA. And it dawned on me that the original legislation that we passed authorizing DNA to be tested in the state was kind of a compromise. And even the Forensic Science Commission was a compromise where we had to satisfy both the needs of the DA's Association as well as the defense bar, rather than, in my opinion, a Forensic Science Commission should have been made up of scientists with no axe to grind and having no place where they wanted to see DNA used and just looked at the science to see how DNA would be used and determined by them in an impartial fashion. But that hasn't been the case, I guess, in my estimation, over the years. And I was really surprised when the Forensic Commission decided to use familial DNA, which I thought needed to be authorized by action of the state legislature before it could be done. But they did it anyway, because maybe it was the commission was too top-heavy with people on one side as opposed to the other. Do you have any comments on that, or how you would expect to see a forensic science commission operate with this dangerous tool that we have, which is a good tool to convict the guilty, but we want it also to be always used to protect the innocent as well?
Sure, I do, and thank you for the question. In terms of the impartiality of the commission, I think it's important to note that there are 2 defense attorneys on the commission now. There's a judge of the appellate division on the commission. There are lab directors on the commission. There's 2 prosecutors on the commission. There's scientists on the commission. So while I certainly respect your opinion on this and all the matters that you speak on, I would have to disagree with regard to the impartiality of the commission. In terms of a commission of strictly scientists, the DNA subcommittee, in fact, serves that role. The DNA subcommittee is made up of exclusively scientists who specialize in different areas of DNA work and who provide binding opinions to the Commission on Forensic Science in any DNA-related areas, including familial search. With regard to familial search, I certainly appreciate your comments about the spectrum and the need to balance along the spectrum. The commission engaged in what I thought was an extensive process. They did public hearings, and during the course of those public hearings, we heard from everyone from folks on one end of the spectrum who said that it's dangerous and it shouldn't be done under any circumstances, to people at the other end of the spectrum, police agencies, in particular, a police agency in particular, who said we should be able to do it whenever we want under any circumstances. The commission and the DNA subcommittee spent a great deal of time evaluating not only all of the input we got in the course of that public hearing, but everything out there, and came up with what I thought was a very restrictive policy that balanced all of the concerns that were raised during the hearing, and frankly, all of the concerns that are out there in the literature. And the policy that the commission came up with, I think if you look at the history, in 1995, the legislature granted the commission authority with regard to the DNA database. In 2010, under that grant of authority, the commission enacted partial match searching. As a result of that partial match searching, a double homicide on Suffolk County was solved, and ultimately someone was convicted because of that partial match information. As a natural extension of that, just over a year ago, the commission authorized in very limited situations familial search. So limited that in the course of a year, there have only been 3 applications granted. So, frankly, we've, as a commission, received a lot of criticism that we came down far too restrictive and far too much on the side of the folks that said that it shouldn't be done at all. But I'm very comfortable with where we came down. I'm comfortable with the fact that all different viewpoints were represented both in the hearings and on the commission, that the concerns were taken very seriously, and that safeguards were put in place to have the process done in a way that utilizes its value and yet safeguards against abuses.
So I might agree with you, and but I might be more comfortable if the commission were made up not of folks who had one philosophy or the other, but just scientists. That's what I'm trying to get at. I would have made up the commission much differently than what we were required to do back in the time when we passed the legislation. And right now, I just want to say, because the legislature is considering important criminal justice reform, then we're embarking upon a new era in criminal justice reform, such as discovery that you talked about, and other things. In your opinion, what do you think can be done to ensure that our forensic labs are reliably performing important tasks relating to examining evidence, for example?
I think there's 2 major areas I'd point to, and the first is the commission and the DNA subcommittee. And the DNA subcommittee, as I indicated, is made up exclusively of scientists who made a binding recommendation to the commission with regard to the familial search, and frankly, they do the same with regard to labs that want to do DNA testing. Secondly, I think the discovery is a great example. I think if the system wants to make sure that DNA is done properly, one of the tools that's necessary is to make sure that the defense has all of the information about the lab and how the testing is done so that those issues can be fully explored in the context of a trial.